I don't know if any of you have been following the lawsuit entitled Below versus Norton. You might have seen it in the Wisconsin Realtors Association. You may have seen a notice coming via email that we had lost that case. And let me explain. I've been trying to find good explanations that I could share with you what that means to us. And the latest update in Wisconsin Magazine had a really nice description of what this means. So we're going to talk about that and give you a little bit of background on what that means to us. A lawsuit was filed with the Wisconsin Supreme Court, and they did come to a conclusion. There is an economic loss doctrine, ELD, applies to residential real estate transactions. What does this mean? All potential legal claims relating to the contract have to be addressed in the contract. Accordingly, there should not be any lawsuits based on misrepresentations, fraud, or negligence, because a party should have provided the remedies they need in their contracts. Provide the remedies that they need in the contracts. The ELD originally was applied to commercial contracts and business deals because typically experienced business people utilize attorneys, and they feel as if they, being the Supreme Court, feels as if the fact that they are sophisticated buyers, that they are generally benefit from the rights and remedies of the Uniform Commercial Code. However, it cannot be said for consumers purchasing a property. The buyers, with the assistance of an agent, typically write up their offers using the offer forms approved by the department and not by attorneys. They do not think or behave like sophisticated professionals negotiating a business deal, so they do not enjoy the Uniform Commercial Code. Sellers are required to make a property condition disclosures in the real estate condition report. Up until now, sellers who misrepresented or concealed the condition of the home were sued for intentional misrepresentation, because the buyer could sue for damages. You've heard of punitive damages where they can obtain more money, and now they're saying that they can't do that anymore. So without the threat of punitive damages, consequences for sellers who lie may be less severe. If a seller gets caught in misrepresentation, the homeowner can still sue for a breach of contract because the offer includes the condition report, and calls for additional property condition representations. But the seller will typically only have to pay to correct the defect that the seller might have lied or concealed. If the worst the seller could face would be to pay for the defect that they had to have paid to fix it to begin with, then sellers may decide not to make truthful disclosures. And the buyer, although they may be able to sue under another doctrine, the buyer is going to sit back and say, how much money is it going to cost me to sue? What is the cost of attorney's fees, the time, the cost, the burden of proof? And then costs a couple $1,000s, and then let's say it's an example of it costs $800 to fix. Who's going to invest a couple $1,000s to prove your point and then have the seller just pay $800 to have it fixed, which they should have done at the beginning? So this is huge. Sellers who do misrepresent the condition of their home may be sued under false advertising statutes. However, what's the kick on here is that the buyer would have to prove that the seller made the false, deceptive, or misleading statement to induce the real estate, but only if the representations were made before the offer to purchase is accepted. Now, what's our liability? Because we are not parties to the purchase, it would appear that the economic loss doctrine would not block misrepresentation losses from agents. The licensee may be found liable for false advertising, but only with respect to misrepresentations or representations knowingly made, false representations. No attorney's fees may be recovered, however. WRA is working to see what they can do to check on different avenues to restore the level of responsibility to the seller. They'd have to work with the legislature to amend the condition report, but the legislature is up till January. And they're also working with the Department of Regulation and Licensing. So what are we supposed to do? Well, visual inspections. I have been talking more and more about the fact that we should have our home inspections done at the time of listing. I think that would help us a lot because the disclosures will be made through that. There's also on Wisconsin Realtors order form. You can receive a listing/selling visual inspection form. that you could fill out when you're walking through. That would help you with your representations. That you're just saying what you know to be true because you have a form that actually shows that you filled it out. Do not ever help the seller fill out the condition report. Don't give advice, and please don't interpret. We've got to try to get this back to them, knowing how important it is that they fill it out to the best of their knowledge. And if the seller fails to make notice of a defect, and you know about it as a licensee, you are obligated through code and licensing law to be able to dictate it to whoever is involved and to disclose it. So I don't think our sellers obviously know about this lawsuit to the extent that they may not be liable, but I'm sure their attorneys do. And I'm going to keep on top of this. It's been kind of an interesting case. But be aware of it. Take that extra step to make sure that you're doing a visual inspection. Still tell the sellers that they have to disclose. I just want you to know what would happen should a lawsuit pursue and that we don't have this doctrine anymore. So thanks for your time and attention. And if you have any questions, give me a holler. Bye.